Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will talk about another important case by the Honorable Supreme Court of India. Its name is Mangala Waman Karandikar through legal representatives versus Prakash Damodar Ranade, Civil Appeal number 10827 of 2010. In this case, the law of contract was discussed and mainly Section 92 and Section 95 of the Indian Evidence Act were involved. The main question that was decided was that whether the meaning of a contract could be culled out solely with reference to the language used in the contract, or could the extrinsic evidence be utilized before adducing proper meaning to the contract. The brief facts of the case were that an agreement was executed between two parties relating to a stationery shop in the name of Karandikar brothers. Now, this stationery shop was given by the first party to the second party, and in lieu of this, it was decided that a sum of rupees 90 per month in form of royalty will be given by the second party to the first party. This would include the business as well as the rent of the shop. This contract was novated from time to time, and in the year 1980, a legal notice to vacate the said premises was given by the first party to the second party, that is, the appellant gave a legal notice to the respondent to conduct her own business. The respondent replied by stating that the contract was a rent agreement and the sale of business was incidental. It was also contended by the respondent that the receipt of payment that was made by him to the appellant mentioned the term rent received, and therefore the contract was primarily a rent agreement and not a contract to conduct business for a specified period. And therefore all the laws and procedures relating to tenancy law would be applicable rather than the general principles of contract. Thereafter, this matter traversed to the trial court, then to the various appellate courts, reaching ultimately to the Honorable Supreme Court of India. As I stated in the beginning, there were two main provisions of law that were involved in this case, Section 92 and Section 95 of the Indian Evidence Act. What does this mean? We'll understand this with the help of the observations of the court. According to the court, it is usual that businessmen often do not sit over the nitty-gritty in a contract, and in any contract, the language used by the parties is susceptible to have more than one meaning, thereby making it the responsibility of the court to decipher the meaning of the words used in a contract, having regards to a meaning reasonable in the line of trade understood by parties. And the court also observed that the path and the development of the law of interpretation has been a progress from a stiff formalism to a strict rationalism. What is the court trying to say? The court was saying all this in reference to Section 92 and 95. Now it is important to understand that the court was referring to Proviso 6 of Section 92 of the Indian Evidence Act, which states that any fact may be proved which shows in what manner the language of a document is related to existing facts. In this regard, the court stated that it is manifest from Section 92 and 95 that it is only in cases where the terms of the document leave the question in doubt then resort could be had to the proviso, but when a document is a straightforward one and presents no difficulty in construing it, the proviso does not apply. It was further observed by the court that Section 92 specifically prohibits evidence of any oral agreement or statement which would contradict, vary, add to, or subtract from its terms. Thus, according to the court, in line with the law laid down, it is clear that the contract mandated continuation of the business in the name of Karandikar brothers by paying royalties of rupees 90 per month. Once the parties have accepted the recitals and the contract, the respondent could not have adduced contrary extrinsic parole evidence unless he portrayed ambiguity in the language. Therefore, any emphasis on the term rent received was misplaced, as the language of the contract was clear and unambiguous, and the impugned contract was a license for continuing existing business, and there could be no question of applicability of any tenancy or rental law. The learned trial court in the present case had ordered the respondent to hand over the suit property to the appellant herein, and such order was basically upheld by the Honorable Supreme Court of India, since according to the court it was a contract that was a license for continuing existing business. So, what are my concluding remarks? To be honest, I found it to be a very interesting judgment, and it was a judgment that dealt with arrangement that was decades old. Deciding age old disputes and bringing them to their logical conclusion is one task that is often found to be neglected. New cases keep coming up, and the old case files are just kept in the record room for rotting. The parties too become wary and start losing interest in such matters. It brings immense joy to my heart when I see the Honorable Apex Court taking up such old disputes and setting a good precedent for the courts of this country to follow their suit in deciding the old cases. This is especially relevant in today's times, as in the garb of COVID-19 pandemic, it is my considered opinion that the civil cases have been unduly neglected by the courts all over. In most of the courts, only criminal matters, and that too only bail matters are being heard. Bail matters are no doubt important and deserve priority over other matters, but that does not mean that the other matters cannot be devoted time to. An unsolicited suggestion perhaps, but when the health professionals and the police are clocking in extra hours these days for the well-being of the citizens of this country, then in a similar manner, I think that the courts could extend their work timings through virtual mode only and start devoting at least some time to civil cases as well, especially the old ones. It is pertinent to note that in ignoring the old cases, the real collateral damage is suffered by the senior citizens of this country, since mostly and invariably it is their disputes who are treated as coldly as possible by the judiciary. By stating this, I do not mean to lower the majesty of the courts in any manner, and in fact, I respect the courts so much that I not only think that they are capable of clocking in extra hours through virtual mode for old civil cases, but also, despite all the difficulties, the bail matters in this country are being heard unfettered all over. It is a welcome move, and I salute the sincerity and commitment of the judicial officers as well as the persons involved in the judicial registries of this country in this regard. Coming back to the present case, I am happy to say that the Honorable Supreme Court of India evinced exemplary interpretational virtuoso in this case. It looks simple at first blush, but the argument of the respondent relating to the term rent received has the capability of confusing any judge, and anyone not well versed with the canons of law of evidence and interpretation would not be able to fathom the depths to which the interpretative process was involved in the present case. Section 92 and Section 95 complicated as well as simplified the matter, in my opinion. Proviso 6 to Section 92 clearly states that any fact may be proved which shows in what manner the language of a document is relating to existing facts, and this provided a potent tool in the hand of the respondent to sway the opinion of the court as to the importance of the term rent received in the secondary documents that were per se not part of the contract between the parties. In my humble opinion, the court very rightly interpreted that when the wordings of the contract is in itself unambiguous, then the interpretational propriety demands that such document ought not to be given any credence at all. And such is the mandate of Section 92 and 95. For the purposes of interpretation in this particular case, it is as if such a document containing the term rent received never existed. It is these simple yet delicate interpretative processes that make reading the judgments of the Honorable Supreme Court of India a true delight. The contract in this case clearly suffused the intention of the parties in an unequivocal manner that the contract was primarily one of a license for continuing existing business and nothing more or nothing less. That is the level of exactitude that a well conducted interpretative exercise is capable of. I also hope that this judgment by the Honorable Supreme Court of India would prove to be a beacon of light for all such old and subsisting contracts in the times to come. So, what is the answer to the question that was put forth in the beginning? That whether the meaning of a contract could be culled out solely with reference to the language used in the contract, or could the extrinsic evidence be utilized before adducing proper meaning to the contract? The answer is that the wordings of the contract are to be looked into, and if the meaning of the words is exact, then there is no need to utilize any extrinsic evidence to ascertain the proper meaning to the terms of the contract. So I hope you enjoyed listening to this show. Thank you for listening. See you next time. Till then, stay tuned.